husband selling assets before divorce. Divorce can be a complicated process, particularly when one spouse starts selling marital assets before the proceedings are finalized. This tactic can significantly impact the financial outcome of a divorce, especially in Texas, where community property laws determine the distribution of assets acquired during the marriage. It's important to understand why a spouse might sell assets, how to recognize the signs, and be aware of the legal consequences to ensure a fair and just resolution. Legal implications of selling assets pre-divorce. Selling assets without the other spouse's permission is not only unethical but also illegal under Texas law. Such actions can be deemed fraudulent, especially if the selling spouse attempts to hide the proceeds. Texas courts can impose severe penalties on the offending spouse. These may include awarding a larger share of the remaining marital assets to the wronged spouse, reducing alimony or child support obligations, or even ordering the offending spouse to pay the other's legal fees. Additionally, the courts may recover the sold asset's value by tracing financial transactions, ensuring fair distribution according to community property laws. Reasons for asset sales before divorce. Some spouses attempt to sell assets before divorce to secure as much cash as possible, hoping to bypass the fair and just distribution of property mandated by Texas law. This strategy is often driven by the desire to maximize personal financial gain at the expense of the other spouse. Unauthorized asset sales aim to subvert this principle, enabling one spouse to take the full monetary value without sharing it. Detecting asset sales early. Detecting asset sales early can prevent significant financial loss. Common signs include unexplained withdrawals from joint accounts, sudden changes in financial behavior, and secretive actions regarding finances. Watch for unusual transactions, missing valuables, or your spouse suddenly insisting on liquidating assets like cars, real estate, or valuable collections. If your spouse becomes evasive about financial matters or insists on managing all finances alone, it could indicate an attempt to conceal asset sales. Texas divorce laws on asset sales. In Texas, divorce laws are designed to ensure an equal distribution of assets and protect the rights of both parties. This section explores the distinctions between community and separate property, the asset disclosure requirements, the consequences of concealing or selling assets, and the specific provisions of the Texas Family Code regarding asset sales before divorce. Community property versus separate property. Texas is a community property state, meaning that most assets acquired during the marriage are considered jointly owned by both spouses. Community property includes income, real estate, and personal property obtained during the marriage. Separate property, on the other hand, consists of assets owned by either spouse before the marriage, inheritances, and gifts received by one spouse. Properly categorizing assets is crucial in divorce proceedings to ensure a fair distribution. Asset disclosure requirements in Texas. During a divorce, both spouses are required to provide a full and honest disclosure of all assets and liabilities. This includes bank accounts, investments, real estate, and any other significant assets. Failing to disclose assets can result in severe penalties, including the court awarding a larger share of the undisclosed assets to the other spouse. Full disclosure helps prevent disputes and ensures a transparent division process. Consequences of concealing or selling assets. Selling or concealing assets before or during a divorce can have serious legal repercussions. Such actions can be deemed fraudulent and lead to penalties. In Texas, fraudulent actions include actual fraud, spending or transferring community property to deprive the other spouse of their fair share. Constructive fraud, unfairly gifting or selling community property or incurring debts without the other spouse's knowledge. Breach of fiduciary duty, acting in self-interest rather than in the best interests of both parties. Penalties for these actions can include financial restitution, adjusting the division of remaining assets, and possibly paying the other spouse's legal fees. Texas Family Code on asset sales before divorce. The Texas Family Code includes provisions to prevent the unauthorized sale or transfer of assets during divorce proceedings. Standing orders, which are typically put into effect once a divorce is filed, prohibit either spouse from selling, transferring, or disposing of any assets without court approval or the other spouse's written consent. These orders aim to maintain the status quo and prevent one spouse from financially harming the other. Exceptions to this rule include reasonable living expenses, permitted expenditures for daily living needs, written agreement, sales or transfers agreed upon in writing by both spouses, normal course of business, business-related transactions that are part of regular operations, normal course of investing, routine investment activities, payment of legal fees, selling assets to cover divorce-related legal costs with court approval, court order, specific court-approved transactions. Protect your financial interests. Understanding the complexities of asset sales before divorce is crucial for protecting your financial interests and ensuring a fair distribution of marital property. Recognizing the signs and knowing the legal implications can empower you to take the necessary steps to safeguard your rights. In Texas, community property laws are designed to ensure that both spouses receive an equal share, making it essential to address any unauthorized asset sales promptly. If you find yourself in this challenging situation, don't hesitate to seek professional legal assistance. Family Matters law firm PLLC is dedicated to helping you address the legal intricacies of divorce and asset protection. Our experienced San Antonio family and divorce lawyers are here to provide the guidance and support you need to achieve a fair outcome. Contact us today at 210-997-2914 or visit us at 926 Chulie Drive, San Antonio, Texas, 78216, United States. Let us help you secure your financial future during this difficult time.